So what are powers of attorney? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota, and New York City. And today we're going to look at powers of attorney. There's a couple different ones to consider and how they fit into your estate plan and into running your business as well. So let's start off first of all with what a power of attorney is. So a power of attorney is a legal document that gives somebody else the power to make legal decisions for you in certain areas. They don't have to be a blanket power, meaning you don't have to give someone the right to make all of the decisions in your life, but they are a very important step for your estate plan and frankly for your business as well, in case something happens to you and we need somebody to be able to make decisions for you. We should also note at the beginning that a power of attorney expires upon your death. So if you appoint your brother as your power of attorney, he can make decisions for you. However, once you die, your estate plan, your will, your trust, your other documents will take over and will govern who makes decisions at that point. Powers of attorney usually come in two different flavors. The first one is a financial power of attorney. And as you can probably guess, the financial power of attorney gives somebody the power to make financial decisions for you. Depending where you're located, your state likely has a basic form, probably available on a website, that lists all of the powers for a power of attorney. And what you normally will do is fill in your information and your power of attorney, the attorney in fact that you're appointing, or the agent. You fill in their information, and then usually on page 2 or 3, there's a long checklist of the various powers. So as I said before, you don't have to give someone all of the powers that are listed. You can choose to give them a limited power of attorney. For example, if you're in another state and you're purchasing property in another state, you could give the power of attorney to somebody else solely for that transaction so that they can buy the real estate in your name without you having to fly across the country, for example, to attend a real estate closing. So it's important, if you're going to look at these financial powers of attorney, that you understand when you sign it, is it going into effect immediately or does it only go into effect when you become incapacitated? There's a big difference, and that can affect what type of form you're going to use when you create your power of attorney. There's also likely a provision in the power of attorney that says whether or not your agent or your attorney in fact can make gifts, meaning to themselves or to other people. And also there'll be a provision about whether or not they can render an accounting, meaning they have to tell you how all the money is spent or give an accounting to somebody on your behalf so that you can keep track of where the money is going if they're exercising that power of attorney. The second type of power of attorney that we run into is a healthcare power of attorney. And this one, just like it sounds, means that if you've become unable to speak for yourself, you can't make medical decisions, you're appointing somebody else to make those decisions for you. Now, just like the financial power of attorney, you want to pay attention as to when this healthcare power of attorney goes into effect. Is it immediate, meaning they can immediately start making healthcare decisions for you, or is it only if you become incapacitated? So if it's only when you become incapacitated, or is there some other provision where a doctor has to say you're incapacitated, or maybe there's a form you sign that officially starts the power of attorney for somebody else? So you need to pay attention to these details in your healthcare form. You also want to make sure that your healthcare power of attorney provides HIPAA access to your agent or your attorney in fact, meaning they can have access to your medical records. We want to make sure that they have all the information available so they're making informed medical decisions for you. Now, if we don't have a power of attorney, what do we have to do? And this is why it's important to have them. Your relatives, your loved ones, whoever's seeking the power would have to start a formal court proceeding. If they need to get power over money, that's usually called a conservatorship. If we need power over medical decisions and making other decisions for you on a personal basis, that can be called a guardianship. But regardless, if you don't have a power of attorney in place and we need to make these decisions and you're sick and can't speak for yourself, your family member, your loved ones may have to institute a formal court proceeding, maybe even hire an attorney, go in front of a judge to get this power, and it's going to be an expensive way to do it when you can simply make sure to have an estate plan with documents that include your powers of attorney. Now, when you're setting up your power of attorney, it's very important that you choose the correct agent, so you want to make sure you're choosing the right person to make those decisions for you. That's the whole point of having this power of attorney, is you don't want somebody else making that decision for you who you wouldn't trust. And if your family members have to go to a court, Somebody will be appointed to make those decisions, but the judge will be the one choosing it, not you. So that's why it's important in our power of attorney that we think who's the right person. And you also usually want to have 1 or 2 backups so that if for some reason the first person is unable to do it, let's say they were in the car with you when the car accident happened, we have somebody else who we trust who can be there to make decisions for you. Now, if you've done your powers of attorney and some time has passed, it's important to check in with your attorney and make sure that it doesn't need to be updated. There's 2 reasons you may want to update it. First of all, if there's been a change in law. You want to find out if your state has changed something with the form, changed the powers. Recently, New York updated their power of attorney form. So if you're in a state where the power of attorney form has recently been updated, it may be a good time to check with your attorney. But also if you want to change the agents, maybe you're not so close with your brother anymore and you're really closer to your sister, or maybe your sister lives close by now and your brother's moved halfway across the world. In that case, it may make more sense to update that power of attorney to make sure it reflects your true wishes right now. So hopefully you can see the importance of powers of attorney and why they should be in your estate plan. If you have more questions or you're ready to get started, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the main page. You can click that and you're taken to my personal calendar. We can set up a legal strategy session, and it's a 15 or 20 minute phone call where we can discuss powers of attorney and your estate plan, whether we're doing a new one or whether we have to update it. Regardless of where you are in this process, it's important that we have an estate plan or at least powers of attorney in place for you in case something happens to you. If you like this video, you can hit the like or the thumbs up button below. You can share it across social media, and I look forward to seeing you in our next video.